This is Kevin Cran. EEO retaliation. Retaliation for engaging in prior EEO activity or for opposing discrimination. Now, there's many types of retaliation: whistleblower retaliation, OSHA-related retaliation, retaliation for engaging in union-related activity. This is not talking about any of those. If you have an EEO case and you are alleging retaliation, you want to be careful that you not mention any other motive other than Title VII retaliation or retaliation based on requesting an accommodation. There are 4 elements to prove a retaliation case. Number 1, you must have engaged in protected activity. Number 2, management must be aware of the protected activity prior to taking the action that's at issue. Number 3, there must be some kind of adverse action that occurred after they were aware. And number 4, there must be some kind of nexus. There must be some kind of connection to your protected activity and to the actions that occurred. Element number 1, protected activity. You participated in EEO activity opposing discrimination. Is it protected activity if you complain to your management and you say that you're being harassed because of whistleblower activity, because of union-related activity? Not for EEO purposes. That might be protected activity for other types of claims, but not for EEO retaliation. You tell your boss, hey, I believe I'm being discriminated against because of my race, my color, my religion, my disability, my age. Yes, that is protected activity. If you tell your boss, I plan on going to EEO, or I plan on filing an EEO complaint, is that protected activity? Yes. Opposition to discrimination, protected activity. Number 2, management has to be aware of your protected activity. To have a motive, they have to be aware of what it is they're retaliating for. You have to prove that they were made aware of your protected activity. Number 3, did an adverse action happen after management was aware of your protected activity? Did you file a sexual harassment complaint? Was the manager aware of it? And did they do something to retaliate? An adverse action can be anything sufficient to dissuade a reasonable employee from filing an EEO complaint. In other words, it has to have a chilling effect, make people not want to file EEO complaints. Number 4, the nexus, connection. How is this connected to your EEO activity? The timing. Did the adverse action occur very shortly after management became aware of your EEO activity? If so, then you have a strong nexus. Is it the same person that is retaliating against you? Is it the same person that you had a prior complaint about? Was that person involved? Were they a named responsible management official? Those are the 4 essential elements to proving a retaliation claim. Management gets to articulate some kind of legitimate, non-discriminatory reason for their actions. And then you ultimately have to show that those reasons are pretexts for discrimination. You can show inconsistencies, you can show contradictions, you can show that statements were made about your EEO activity or about your protected activity. You can use comparators to show that similarly situated individuals were not treated the same. There are many ways to show that the agency's articulated reasons are nothing but pretext for discrimination. So I hope this is helpful, because you have to prove all of these 4 elements, because a judge eventually is going to look at the case, and a judge is going to want to see that you can make out your essential case first before you even move forward to a trial or a hearing. This is attorney Kevin Cran from Cran Law.